Okay, hi everybody. Thanks for joining us today. I'm really excited to be hosting such knowledgeable people in the expungement world. This is, I think, going to be super valuable training for those at any experience level because of changes to the law and just learning about new opportunities to get involved and volunteer if you don't already do that. So for those of you who don't know me, my name is Paulina Kennedy. I'm an attorney at Whites and Luxembourg, which is a plaintiff's firm, and we're based in Detroit in the Fisher Building. And I am currently serving on the Women Lawyers Association of Michigan Wayne Region Board. My role is just wrapping up, but I was the director of social media this past year. And for the new term, pending approval by vote, I will be doing director of membership. So we will be sending a follow-up email too. And in the survey, for those of you who are taking this training for credit, there is a link to learn more about Women Lawyers Association of Michigan. If you're not already plugged in, we would love to have you. I want to do a quick thank you to Kirsten Slanowitz and Christina Joseph, who are the presidents of the Women Lawyers Association of Michigan, Wayne and Macomb boards. They worked together to put this training on so that we could offer it to both regions. And we're very hopeful that next year we may be able to offer another training, and we really want to expand and grow to the statewide Women Lawyers Association so that eventually we can do our own clinic or something like that. So I will just transition now to introducing the speakers for the event. We're going to start off with a review of the law around expungements presented by Ann Yantis, who has had an extensive and impressive career with State Appellate Defender's Office. She's a sentencing law expert, and after her time at SADO, she was a professor at Detroit Mercy Law, which is where I met her. And then she briefly did pro bono management program at Bodman, and now she currently works for herself, if I'm understanding that correctly.
Yes.
So we're extremely lucky to have her. And then following that presentation, we'll hear from Judge Michelle Rick, who has a passion for expungements. She's been on the bench, at one bench or another, since 2007. She was originally appointed to a circuit court in 2007 and was elected to the Court of Appeals, where she has been since January of 2021. She is an adjunct professor at Detroit Mercy Law as well, and she teaches access to justice. And like I said, has just been passionate about expungement, and I'm sure she will tell you more about her role in that. And then finally, we're also joined by Kamau Sandiford from Safe and Just Michigan. He is the Clean Slate Program Manager, and he's going to tell you more about what Clean Slate is and how you can get involved with volunteering with some of their fairs. And he's also previously or currently still, I'm not totally sure about that, but the expungement clinic director for Cooley Law. So he's got a lot of practical experience, and we look forward to him chiming in through the presentation as well. Okay, so without further ado, Ann Yantis.
Okay, so let me share my slides. And I'm assuming you can see the slides. All right, so I can see them, so I'm assuming you can see them. Okay, so
Okay.
We can't
Did
see
you
them.
put your screen at the bottom?
Oh, you know, I knew I forgot something. It felt like it was too simple. All right, hang on one second. Where did I go with my
different person's screen?
You would think.
We're currently seeing, I think, Judge Jokic's screen.
Okay.
For some reason.
All right, so I'm going to, yes, here we go. So here we go. All
Okay.
right, can you see my slides? Good, now I need to This is where I always get in trouble, where I need to shoot.
I like using the bottom. If you see at the bottom where there's like a zoom in function, right to the left of that is a little icon. Yep.
Oh, you can see what I'm doing. Okay, so what is, oh, so that's showing me the slideshow. Oh, good, thank you.
Yep.
Yeah, I always get stuck on that, and I'm sorry, I should figure it out before I speak. I know, I apologize. Okay, anyway, let's get started. So I think I have 40 minutes, and I'm going to move fairly quickly through the statutes themselves and sort of what the law appears to be. I think Kamau can answer a lot of the practical questions. And I recall that Judge Rick, I think, may cover some of the questions about who is served and, you know, how you get it into court. But if not, you know, we can answer those questions at the end. So if you're new to this, let me just tell you in terms of terminology that it's actually not referred to in the statute as expungement. It's referred to as setting aside a conviction, although everyone calls it expungement, but it's technically setting aside a conviction. And the other thing that's important to know up front is if you have no criminal law experience, this may be a surprise to you, but if you have criminal law experience, it's not. So in Michigan, we have felonies and we have misdemeanors. And usually the cutoff for a misdemeanor is that it has a statutory maximum penalty of no more than a year. But there are some hybrid offenses that are called 2-year misdemeanors. They have a maximum penalty of 2 years, but the legislature may designate them as a misdemeanor. Sometimes the legislature calls it a felony in the statute, but a lot of times they call it a misdemeanor. And that has consequences, you know, outside of the application of criminal law. You know, the individual can say they've only been convicted of a misdemeanor. And I think it may have consequences for weapons licensing or something. I know it has some meaning, but for our purposes, a 2-year misdemeanor counts as a felony. And that's not only because that's the case in most, you know, for most of the criminal law statutes, but it's also written into the set-aside statutes that anything that has a maximum penalty over a year is considered a felony, or anything that's designated in the statute as a felony. All right, so the other thing I'd like to say is, and I hope I don't sound too preachy here, always check the statute. And, you know, I was an appellate attorney for a very long time. And really the first thing I would ever do when I was sitting down to write up something, to write an argument, was to look at the statute or look at the Constitution or whatever it was. And with these set-aside statutes, you really, really need to look at the statute. And it's great if you have a good sense of it, but I find I'm always going back to the statute, even though I've done multiple trainings on this, and I feel like I have a pretty good handle on it. But number one, your memory is not perfect. And number two, you know, you think that the language is this and the language is just slightly different, and it can make a difference. And my experience is that people will ask me questions about expunging a conviction, and if they just looked at the statute, they could easily answer the question. And so it suggests to me that people maybe have a fear of looking at the statute, or they don't have enough time. But I say, you know, always look at the statute. You can never go wrong. All right, so in my opinion, there are 3 discrete areas that we could be talking about, but I'm only talking about 2 because of time limits. So I'll talk about the traditional application process and then the misdemeanor marijuana set-asides. The automatic set-aside process has not taken effect yet, and because of time limits, we're not going to talk about it. Now, when I say the traditional application process, what I mean is there's been an expungement statute for a number of years on the books, although it was very limited, and until 2021. But you have to file an application. You know, it was not automatic at all. And so there are rules that have changed now as of 2021 for, you know, the traditional application process, and we'll go through those. And then with the misdemeanor marijuana set-asides, you do have to file an application. It's not an automatic set-aside. All right, so what is not accomplished by a set-aside, and this is written into the statutes, there's still a non-public record that's available to certain entities. The individual does not obtain a return of fines, costs, and assessments already paid. And then they must still pay restitution if there's an outstanding balance. And I was looking through some of the statutes this morning to just refresh myself on a couple of minor points. And I was reminded that there is a provision in the statutes that a court can reinstate an expunged conviction if the court finds that the individual has not made a good faith effort to pay restitution. So if you don't keep paying your restitution, that conviction can come back. And then the last point is the conviction is still available for sentence enhancement purposes. So down the line, if you are charged with a crime, they can allege that, it's not your first time or that you're a habitual offender. And, that's proper. And it can be considered for sentencing decisions on a new crime if the new crime has a maximum penalty of more than a year. So there's sentence enhancement, which, sort of statutorily would increase the penalty, but then there's also considering it at sentencing itself if the maximum penalty is more than 1 year. And so the statutes, if you're going to look at them for the traditional application of an adult conviction, are this is 780.621, and then the statutes that follow. There's quite a few actually at this point. And then if it's a juvenile adjudication, there's a separate statute. I don't know this area very well, but it's MCL 712A.18E. All right, so we're going to talk about 3 different areas today on the traditional application process: who's eligible, and then which offenses are eligible, and then the waiting period. And for the most part, I think the questions are pretty much on the waiting period. But if you have a question on who is eligible or ineligible offenses, I'm thinking, Paulina, that they can put it in the chat.
Yes, I'm monitoring the chat.
Okay, all right, and then she can interrupt me. And I told Kamau if he has a point to make that, he thinks is important, he can interrupt me as well. All right, so who's eligible? We're going to talk about 3 parts of the statute. So it depends on the number of felony convictions you have. Then there's the same transaction rule, and then there's these global restrictions that I call subdivision B and C. But let me just give you some context here. For most of my career, there was, an expungement statute, and it was at MCL 780.621. But until 2011, it was pretty simple. You could set aside 1 conviction, and you couldn't have any other convictions on your record. And then there were ineligible offenses, and that's pretty much what it was. And then in June of 2011, the legislature opened it up a little so that you could set aside 1 conviction, even if you had 2 additional minor offense convictions on your record. And minor offense conviction was defined as a statutory maximum penalty of 90 days or less, and you had to have committed it under the age of 21. And then there was a significant change in January of 2015, which was you could set aside either 1 felony or 2 misdemeanors. And I'm going to guess, and Judge Rick can tell us when she gets into her portion, I think she's been involved since that change, because my recollection is there were always some questions about, how that worked. And I know that people have been doing a lot of expungement work since January of 2015. But these changes that we're talking about today took effect in 2021. And so this is the sort of introductory provision of 780.621, the very first of the statutes. It says, except as provided in subdivisions B and C. Now, those are what I consider the global restrictions, and I'll get to them in a minute, but just hold on to that thought. So except for those subdivisions, a person convicted of 1 or more criminal offenses, but not more than a total of 3 felony offenses in the state, may apply to have 1 or more of the convictions set aside. The way that this is worded, it seems to be focused on the person. So it's the person and the qualifications the person has. So when they say not more than 3 felony offenses, people have asked me, well, if you have 4, can you just, set aside 3? I think the answer generally is no, unless, your 4 somehow qualifies as 3 under the same transaction rule. And the reason I say that is the way the statute is worded. A person who has not more than 3 felony offenses. So that seems to say that you are disqualified as an individual if you have more than 3 felony offenses on your record. Now, of course, we'll get into the same transaction rule in a minute because you may have an exception there. All right, so what if you have more than 3 felonies? Well, maybe you can slide in under the same transaction rule, also called the 1 bad night rule. And the offenses, you'd have to have multiple felonies that were committed during the same transaction and within 24 hours. So, at least 2 or 3 of your, 4 or 5 or however many felonies you'd have to have that were committed during the same transaction and within 24 hours. And if that's the case, then you can take the multiple felony convictions and treat them as 1 felony, or if they were misdemeanor convictions, you could treat them as 1 misdemeanor. But there is a caveat there, and I wanted to work through a couple of hypotheticals so that you can understand this. So what if a person has 5 felony convictions, 3 arose from the same transaction? Would they be eligible? And you may be inclined to say yes, because they meet the same transaction test, but there are some restrictions there. The same transaction rule does not apply to assaultive crimes. It doesn't apply to crimes involving use or possession of a dangerous weapon, and it doesn't apply to crimes with a maximum penalty of 10 years or more. So I want you don't have to memorize that. I think if you encounter a same transaction setting where it sounds like, from what the client tells you, that there may be same transaction offenses, then you go back and look at the statute. But I'm going to show you, for purposes of our hypothetical, how this will work. So this person has 5 felony convictions on their record. There's 1 is larceny in a building, which is a relatively low-level felony. 1 is retail fraud first, a low-level felony. And then 3 unlawful driving away of an automobile, which is relatively low level. This is otherwise known as car theft. Now, from what the client tells you, and given that the person was convicted at the same time, it sounds like they were, convicted, that they arose out of the same transaction. So is this person eligible? Well, you have to remember, you have to know whether these crimes that are going to possibly be eligible for the same transaction exception were assaultive crimes. That's the first part, right? Unlawful driving away of an auto is not an assaultive crime, so you're okay there. Now you have to know whether it's a weapons offense. No. Then you have to know whether it's a felony with a maximum penalty of 10 years or more. Well, it has a maximum penalty of 5 years. And if you don't happen to know that off the top of your head, you can just, take your phone and put in unlawful driving away of an auto. It'll pull up the statute and you'll find the penalty. So the answer here is yes. It appears that those 3 unlawful driving away of an auto will count as 1 under the same transaction rule. That means the person has no more than 3 felony convictions on their record. And then I put down here at the bottom of the slide that there's also no violation of those global subdivisions B or C, which I think we are getting into right now. Okay. So the general rule, no more than 3 felony convictions. Subdivision B, it's a global restriction that, I think some people sort of look at the very end of their screening process for both B and C. It's like you've gone through everything, whether the person is eligible, whether the offenses are eligible, whether you've met the wait period. And then, I think, it makes sense to then consider subdivisions B and C to make sure there's no violation of these global restrictions. I like to kind of cover them up front though. So subdivision B is that the individual can have no more than 2 convictions for an assaultive crime set aside in their lifetime. So even if you're otherwise eligible, you can only have 2 assaultive crimes set aside in a lifetime. Subdivision C is, and this one's a little tricky, an applicant may not have more than 1 felony conviction for the same offense set aside if the offense is punishable by more than 10 years imprisonment. What they mean is if you have 3 convictions for unlawful driving away of an automobile, that's the same offense, and those are felonies. So you need to know, is the maximum penalty more than 10 years imprisonment? Turns out it's not, so there's not a problem there. But if you had a felony, say you committed, I don't want to ruin one of my upcoming hypotheticals, but say you committed a murder and then 5 years later, you had another murder, and for some reason, you were trying to set these aside. You probably couldn't, but you couldn't set aside more than one if it was the same crime and it had a maximum penalty of more than 10 years. All right, so here's my hypothetical. Person has 5 felony convictions. We're going to assume that the 3 unarmed robberies are counting as 1 under the same transaction test. They also have a larceny in a building and retail fraud. So I want you to think to yourself, well, is this person eligible? And do they meet subdivisions B and C? Subdivision B is no more than 2 assaultive crimes set aside in your lifetime. Subdivision C is if you have multiple felonies for the same offense and they have a maximum penalty of more than 10 years, you can only set aside 1. So where are we at on this? Well, unarmed robbery is an assaultive crime and you've got 3, and you're only allowed to set aside 2 assaultive crimes in your lifetime. It also has a 15-year maximum penalty. So you'd be trying to set aside 3 of the same offense with a maximum penalty of more than 10 years. So the answer is no, that it's essentially, you're going to, why do I think it counts as 5 felonies? Oh, because unarmed robbery is assaultive. So you're not going to qualify for the same transaction test because it's the unarmed robberies are assaultive. You're also going to violate subdivisions B and C because you can't set aside more than 2 assaultive crimes in your lifetime. In subdivision C, you can't set aside more than 1 felony that's the same as other felony offenses with a maximum penalty of more than 10 years. Now, for some of you, if you're brand new to this, you may be thinking, okay, this is overwhelming. I don't see a lot of faces on my screen, so I'm not seeing people shaking their head, but sometimes I look at it and I think, all right, this gets crazy. But it's not as bad as you think. It's just remember subdivisions B and C are sort of these global restrictions. Look at them at the end. But always remember 3 felonies and your same transaction rule. So, yep, there's my recap. No more than 3 felony convictions unless you have same transaction exception. Same transaction rule does not apply to assaultive crimes, weapons crimes, well, really dangerous weapon, and then crimes with a maximum penalty of 10 years or more. And then your subdivisions B and C, your global restrictions. So that's who is eligible. I'm now going to go into the ineligible offenses. And I guess I better keep moving on. So ineligible offenses. Yes, there are some that are ineligible. The big category is no crimes that have a life maximum penalty, including attempts to commit those crimes. And what they mean here is if the statutory maximum penalty is life or life for any term of years, regardless of what sentence the person received, that crime is ineligible. And then the statute also talks about other crimes that are ineligible: felony child abuse, most of your sex crimes and attempts to commit them, your felony domestic violence if you have a misdemeanor domestic violence, no human trafficking offenses, and they mean perpetrators of human trafficking, not victims. And then it used to be that you could not set aside a traffic offense. That has been changed, but there are some traffic offenses that cannot be set aside. So what are the traffic offenses? All right, so you probably know that you can set aside your first drunk driving conviction if you have no other drunk driving conviction, and it doesn't involve injury or death, and it doesn't involve a commercial motor vehicle offense. You can set aside your first drunk driving conviction. You cannot set aside a second drunk driving conviction or a third. I put down OWI, that's operating while intoxicated, second or subsequent offense, but it's really second or third. There is no charge for fourth. If there's a fourth, the highest they can charge you with is third. So you can't set aside a second or third. There's a common question about whether you could set aside one and then later come back and say it's your first. The answer is no. It's written in such a way that you can't do that. All right. By the way, when I say, and I was talking about drunk driving, but these restrictions for traffic offenses causing injury or death on commercial motor vehicle, those apply to any traffic offense. All right, so is this person eligible to set aside their convictions? You've got a carjacking, which is a felony. You've got a misdemeanor drunk driving, and you've got a misdemeanor driving with a suspended license. So I hope that you're thinking to yourself, all right, let me test myself here. All right, so they have no more than 3 felonies on the record, right? They only have the one carjacking. You have 2, misdemeanors. So sounds like we're okay there. But what about ineligible offenses? So let's start with the traffic offenses. So a first offense, operating while intoxicated, that's probably okay, no problem there. And driving with a suspended license, assuming there was no injury or death or commercial motor vehicle violation, you're okay there. But carjacking, do you know off the top of your head what the penalty is for carjacking? It's life or any term of years. So you cannot set aside the carjacking, although you can set aside the drunk driving and the suspended license, assuming no injury, death, and commercial motor vehicle. All right, so I get a common question here that people ask me this all the time. What if the penalty has changed? And I'm going to go relatively quickly here because I don't want to go past my time. But you know that crimes with a life maximum penalty are precluded, right? So I got this question, and then there's a second one that follows. And I'm going to walk you through how I would analyze it. What if the person was convicted of arson in a dwelling in 2010 when the maximum penalty was 20 years, but then the arson statutes were amended as of, I forget when, and now arson of a dwelling, if it involves multiple units or injury, is arson in the first degree, and that has a life maximum penalty. And let's assume that this person, when they were convicted of arson in a dwelling in 2010, that there were multiple units involved, so that now it would be a life offense. And then a very similar question I received was, what happens if they were convicted of delivery of heroin over 650 grams back in 2000 when it was a life maximum penalty? And now the penalty is 30 years if the amount is between 450 and 1,000. And then if it's over 1,000, I think it goes to life. But in any event, it's, the penalty has changed, right? So that in the one, it was not a life offense when committed, and in the other, it was a life offense when committed, and it's changed. So I will say this, always look at the statute, and the courts have to decide this, obviously. And just in terms of your equities, I think it's more sympathetic if the crime was a lesser crime when committed, because it kind of seems unfair to treat it like a more serious crime for expungement purposes when it wasn't when it was committed. On the other hand, if the penalty was higher when it was committed and it's now lower, you could argue that we don't view that as that serious anymore, and maybe they should get a break. But if you look at the statute, let me tell you some different approaches here. Statute says you can't set aside a felony for which the maximum punishment is life imprisonment. It's written in the present tense. It doesn't say was life imprisonment, it says is life imprisonment. And so one way the courts may look at it is they're looking at the penalty today. And I'm not going to worry about that. And so here's another possible argument, though, for why you want to look at what the penalty was when it was committed. Under the legislative sentencing guidelines, in terms of classifying prior felony convictions, there are high severity and low severity. There's some unpublished case law, and this is just by analogy, obviously, and it's not a perfect analogy, but there's some unpublished case law that says you look, that basically says if it was a misdemeanor when you committed it and it's now a felony, we're not going to treat it as a felony under the guidelines. So that gives you a little bit of ammunition, but this is a very unclear area. That's the best I can offer. All right, so we talked about the first two areas. Let's talk about the waiting period. This is where it gets a little tricky. All right, so if you have 2 or more felony convictions, your waiting period is 7 years. You cannot file for at least 7 years. If you have 1 felony or 1 or more serious misdemeanors, you cannot file for at least 5 years. And 1 or more non-serious misdemeanors, 3 years. And they define serious misdemeanor in the statute. There is no waiting period for misdemeanor marijuana set-asides, and for some human trafficking crimes where you are the victim, not the perpetrator. How do you know when the waiting period starts? It's from the last of the following events. If you received fines and costs and no probation or no imprisonment, then it's just from the date of sentence. If you received probation, it's from when you completed. If you received prison and there was no parole, you just served the whole prison sentence, it would be from the date you finished the prison sentence. Or if you were given parole, it would be from completion of parole. This is where it gets tricky. A court may not set aside a conviction if the applicant has pending criminal charges. Well, that part's easy. If your client says they have pending criminal charges, tell them they're not eligible. They're going to have to wait till they are resolved. And if they're convicted of the new charges, you're going to have a new wait period. But it's the second part. The applicant has no new conviction during the waiting period. And the way that the statute reads, it tells you, you know, your time periods, right? And I think I'm going to move forward here. But it also says the applicant has not been convicted of any criminal offense during the applicable time period. So I'm going to go through two quick hypotheticals to sort of walk you through the different interpretations here. There are, I think, several different interpretations of what the waiting period is and what it means to have no new conviction during the applicable time period. And if you've done any work on this, you're probably familiar with the way the legislature didn't write the statutes as well as they could have. All right, so I thought I'd start with maybe the simplest hypothetical I could think of. So this is your, once again, larceny in a building, a retail fraud first, and driving with a suspended license. You look at the time periods of when they would have completed everything. The larceny in a building would have been finished in 1996, the retail fraud in 2005, and the driving with suspended license in 2013. So you have 2 felony convictions here and 1 misdemeanor, right? So your wait period for the felonies, for 2 felonies, is going to be 7 years. And your wait period for a non-serious misdemeanor is going to be 3 years. So does this person qualify? Well, I mean, you've gone 7 years from 1996 to 2005. You've gone at least 7 years with no new conviction during the wait period. So arguably, you know, you may argue that person, you know, meets the test. And then from 2005 to 2013 is at least 7 years. So you could argue, you know, you've been okay there. And then you've gone at least 3 years since your non-serious misdemeanor. So, you know, you could argue you're okay there. So the answer is probably yes, but I say only probably because if a court reads that the language "you've had no new conviction during the applicable wait period" as meaning that literally that the larceny and billing, the wait period is 7 years or more, and they did have a new conviction somewhere between 7 or more. And the same thing with the retail fraud. You know, you could, you know, a court could take a very rigid, literal approach and say, all right, the only thing you could set aside would be the driving with a suspended license because you've had no new conviction and you've gone at least 3 years. I don't think the courts are saying that, but, you know, that's this thing that lingers out there. It seems like what most people are saying is you look at the last conviction and you start the wait period from the last conviction. And you don't necessarily use the wait period for the last conviction. You use the highest wait period, which in this case would be 7 years for the felony. And if that's the case, this person qualifies. I'm going to change it to make it a little trickier though, because in this case, you still got 2 felonies and a non-serious misdemeanor. but you clearly had the second felony during the wait period, the 7-year wait period from the first felony, assuming it started at the end of the first felony. And that makes it a little tricky. Again, if you take the approach that the wait period starts at the end of the string of convictions, then this person is okay. But, could a court say, well, you did have a conviction during, the applicable wait period? It's possible. Misdemeanor marijuana set-asides, I will say this, it's actually it's pretty straightforward. So if you're feeling like there's been a lot of information, this part's really easy to follow. Recreational marijuana became legal in Michigan in December of 2018. And if you recall, and I'm sure you have a very good memory, we voted on that. That was not the legislature. We voted on that. And so what do you do with these old marijuana convictions that would not be a crime if committed now? Can you set them aside? There are special rules for setting them aside. You do have to file an application. There's no waiting period. It's written into the statute, no waiting period. What is a misdemeanor marijuana conviction? It's possession of marijuana, use of marijuana, marijuana paraphernalia, and a local ordinance substantially corresponding to those. And no wait period. And really that's all that this slide says. The statute says beginning on January 1st of 2020, but the statute didn't become effective until April of 2021. So, you couldn't do anything till at least April of 2021. Once you file the application, there's a rebuttable presumption that the conviction, if it's one of those that I listed, would not have been a crime if committed before December 6th, on or after December 6th of 2018, the date on which that behavior was legalized. Prosecutor has 60 days to file an answer rebutting it. And they may say, no, your conviction was for something else. Or, they may come up with some argument that technically you don't qualify. If the prosecutor files a rebuttal, a timely one, the court must set a hearing within 30 days. If the prosecutor files no answer, the court must grant the application within 21 days. No discretion. The court doesn't get to say, well, I'm just not going to do this. The court must do this. Unlike your traditional application, when it comes to misdemeanor marijuana, they must grant it if you meet the requirements. But the losing party can file for rehearing, reconsideration, or appeal. What you do not get with a set aside of a misdemeanor marijuana, no return of fines, costs, fees, and you don't get a resentencing on prior convictions where that misdemeanor marijuana conviction was used either to enhance the crime or to score the sentencing guidelines or was considered at sentencing. You don't get to disturb prior convictions. Same transaction rule applies, and there's still a non-public record. I think that's pretty much it, except if for some reason your application is denied, if the judge, says I'm going to deny it, it's written into the statute that you can't refile for 3 years unless the court provides otherwise. And so you need to get it in the order that you can refile before 3 years. And that is my talk. All right.
Thank you so much. We could take maybe about 5 to 10 minutes of questions if anybody has anything before we switch over to Judge Rick.
And Kamau, if you want to jump in on any point or sort of add to something I said. So there's a question about convictions that are deferred. I recall that if you avoided a conviction under HIDA, the Homeless Youthful Trainee Act, I think it still counts as a misdemeanor for determining, how many convictions you have on your record. And I think the drug deferral 7411 is the same thing. And there may be some other ones, probably like, I'm not sure if domestic violence also counts, but you have to check the statute if you've got a deferred, something that ended up being avoiding a conviction.
Can I speak up to elaborate on my question?
Sure.
I'm the HIDA question, not a criminal attorney. So I have a client with a HIDA conviction, and it doesn't affect her eligibility. But the question I have is about disclosing it, right? Because it's not allowed to be part of the public record. So do I file a motion to file that information under seal? Or how do you protect the confidentiality of that HIDA conviction in this proceeding?
All right, so let me just say, and I know you're doing to criminal law, I would not call it a HIDA conviction. I would call it a HIDA disposition.
HIDA disposition.
Yeah, it's not a conviction. All right, so it's a non-conviction. So number one, at first I thought you were asking how to get more information on it from the court, because once you successfully complete the probation under HIDA, the record is sealed. But I think what you're asking is, how do you keep that from coming out in the expungement process in terms of the public record? And, I have not run into that. I suppose you could file a motion. Kamau, are you there? Do you have any suggestions?
In cases like that, I have literally just written HIDA in the question. I forget which number it is. I think it's like question 6.
Question 5.
5, and I haven't disclosed the actual conviction.
Okay.
And I will say, when the MSP lien report comes back, the HIDA case will show up on the lien report, but I don't believe they make it part of the public file. So for that very reason. So the judge will have access to it. You guys will have access to it, but I don't believe the public would have access to that lien report.
So I think Kamau is saying that on the application, you say HIDA, but you don't say what it was.
Yes.
Right.
And I think, I was going to offer that to my client, because even the existence of a HIDA conviction is supposed to be non-public, or a HIDA disposition, just like the fact of it.
Yeah, and I like that you're, really trying to protect your client here. So, you might just send information about assuming you have some documentation of the non-conviction, you could send it, by confidential letter to the judge or something, and copy the prosecutor. But I wouldn't file it in the circuit court or the district court, because, once it gets filed, unless you move to seal it, it's going to be open to the public.
I will say as well, on the application, I believe they also ask you, like, have you previously had any convictions expunged, which would be equivalent to the HIDA analogy. I have disclosed the fact that, yes, this person has had previous convictions expunged, because they asked me to. I'm not sure if there's a workaround for that issue, so yeah.
The good news is people don't usually go and actually look at the record. But now that most things are online, it's very easy to look. But
right, all that information can be mined pretty easily. So,
well, yes and no, because usually you can't get the pleadings online. At least that's been my experience. You can get the docket entries, but you can't get the pleadings. So you'd have to go in person to see the pleadings. Normally, I think that's been my experience.
thank you.
That was a tricky one. We have a couple other ones in the chat now. Should someone try to set aside a conviction for marijuana if it was taken under HIDA, even though it's not really a conviction?
Well, it's not a conviction, so how would you set it aside? When you're trying to set aside the HIDA, that wouldn't make Kamau, am I missing something here?
No, I think you basically can't expunge something that's already been expunged. That's what it boils down to. So to answer that question, you wouldn't be able to do anything with respect.
Okay, so yeah, sounds like no. Sounds like you wouldn't need to. And then the other question was, If somebody injured a person during a traffic offense but pleaded to a reduced charge like reckless driving, are they eligible for expungement, or do the real facts create a barrier?
And I'll let Kamau tell us if he's had any experience here, but the statutory language, if I recall, is that it involved injury or death, not that you were charged or convicted of an, but you know, I'm not sure it's completely clear. And Kamau, have you had any experience on this?
Yeah, so I've had a couple of clients who are trying to expunge, for example, driving on suspended license convictions, which are traffic offenses that you wouldn't necessarily associate with an injury. And the judge would inquire, you know, did this traffic offense involve any type of injury to satisfy the statutory requirements? So to answer your question, based off of what I've seen, the courts will rely on the underlying facts of that particular case to determine whether there's an injury involved, or you know, whether it meets, it's excluded under the statute.
Yeah, that's how I would read the statute. But again, we don't have any court interpretation of it. But yeah, I agree with Kamau on that.
Okay, thank you very much for the presentation. And I'm going to turn it over to Judge Rick now to talk about the practical application process and also some of her experience with expungements.
Thank you, Paulina. And it was a great presentation as always. And Kamau, glad to be in your presence. Thank you for being here today. There are several former students of mine from Detroit Mercy who are on. Maya Eunice and Jayla Emerson and Becca Zaris. And Becca was one of the students who was part of this experiment where we conducted a traveling expungement clinic through lower northern Michigan right before the pandemic hit the year prior. I know that Becca has to be excited, as I am, about the changes in the law. I mean, I'm thinking of specific applicants whom we encountered along our way under the old system, the 1 felony, 2 misdemeanor maximum, and how challenging and heartbreaking it was to have to tell people, we're sorry you don't qualify. And one person in particular, a mom in her 50s who at the age of 19 pled straight up to 2 felony larceny convictions without counsel and without, any understanding that she would be plagued and it would be effectively a life sentence for her. And my hope is, as we are educating attorneys and law students about the changes in the expungement laws, my hope is that communities where maybe there have been clinics in the past, that people will recognize all is not lost and that they will have a renewed spirit of hope. Now, I've got a slideshow and I'm going to be sharing my screen momentarily, but a couple of things I want to cover just ever so briefly. First of all, with very limited exception, ultimately it is the judge's discretion about whether or not to grant an expungement. That is to say, even though a person may qualify, you as practitioners will need to inform your client that while things look great on paper, ultimately it's going to be the judge's discretion. And as that is the case, it is critical that your applications be squeaky clean, acknowledge even the ugly things, and you prep that client. If you're not going, when we did our expungement clinic, we did a one and done. So we came in and got everything filed on behalf of the client, but then they had to subsequently appear before the judge or before their judges to make their case. And that is a vital piece that you must cover with your clients. So those conversations that you may have if you have a criminal practice about wearing your Sunday best, not being argumentative, putting your best face forward, bring the letters from your church and the community, etc. All of that is really important. I know that those kinds of things were persuasive for me. It didn't take a lot of persuading for me to grant expungements. I love expungements. I think it's a beautiful point in one's life if they qualify. But and I know that Judge Jokic, who is also on this call, she is a firm believer in restorative justice, giving people second chances when they earn them. You will not necessarily have judges who align themselves with Judge Jokic and myself. They want to see that there really is a good reason to set aside, even though, all of the statutory requirements have been met. So, that prep of your client at the end, when you go in for your hearing, is really, really critical. So with that, I want to turn to my slideshow, and I was really glad to know that piece of advice from Paulina about how to get your slideshow up and running. It looks like it was this one. Let's see. Yes. Okay, so we have Lady Justice here, and we're going to talk about creating that expungement application. And when I say, where the heck do I begin? I don't want that to be a frightening thing for you. There are resources out there. I'm going to be talking about iChat, and I think I have some slides on Michigan Legal Help. So you are not going it alone, in addition to having the sage advice from your speakers here today. But you're going to start out by interviewing your client, and there are some really critical things that you need to ascertain. I've got them listed out here. You'll see the fourth bullet is a rather wordy, but it's important that as best you're able to reconstruct the client's understanding of past criminal contacts. What is remarkable to me, and a great takeaway from our traveling expungement clinic, was that people don't always know what they've been convicted of or where. And so, as best that you are able to walk them through that reconstruction, it will be very useful, though we will be using iChat to confirm those details. I have in that same bullet, a reference to being a victim of human trafficking. Sometimes that is not always evident, and it may not be evident to the client, him or herself. And so you may have to tease that out about asking other types of questions than just, do you identify as a victim of human trafficking? And that's something that as practitioners, I am confident that you will have those capabilities, but I'm happy to chat with you after today if you have any questions about that. So you've conducted your client interview, you've taken copious notes, and then you are going to trust but verify. And you do so by running the iChat. And I have the link on the screen that you would use to go to iChat. And now I want you to suspend reality for just a moment and pretend that I'm actually clicking that link. And if I did click that link, this is the page that we would come to. The iChat is the Internet Criminal History Access Tool. This is maintained by the Department of State Police. And on my slide, I have circled and highlighted the button that you will click to get started to run that background check from iChat. Now, notably, iChat only covers state of Michigan convictions. So if you have a client who has an out-of-state conviction, you will need to know that. Or if they've had federal charges, you will need to know that. But you will not be able to confirm that information on iChat, but it will be important, right? Because when your client eventually goes before the judge, assuming that those other out-of-state or federal matters are not prohibitive, you certainly don't want to appear to be hiding anything. And the state police is going to be conducting a comprehensive background check after your client's application is submitted. So they will unearth that information. So I've clicked the button that I've highlighted, and you will see there are 2 ways in which to log on to iChat. I think probably returning users would be those individuals who are either employers or maybe are hosts of clinics. But assuming that you are doing this kind of independently, you may log on as a guest user, and that is perfectly acceptable. So you can, again, assume that I have logged on as a guest user, and I will come to you will see this screen where you input all the relevant information that you've obtained from your client. And if you don't have any information pertaining to middle name or a suffix, you can see those are not asterisked anyway as mandatory information. SID is if you have the information that is the numeric information from the state of Michigan, you can click on that link for more information, but assuming that they have a Department of Corrections ID as a former prisoner, then or a probationer, then that might be what you input. Before you can get any further, after you've input all that personal information from your client, the state police requires that you pay them before they give you any of the information you're seeking. So you'll have to either utilize, if your client is providing a form of payment, or if you've got a payment that is a method maybe supplied by Department of Michigan Works or some other entity, this is where you would have to designate that. Now, this next screen assumes that I've put in information and the individual has no record. So you'll see on the screen itself that I've paid my $10 and that according to the state police, there is no criminal record. Now that could be accurate or it could be erroneous. I'll show you in a minute what the state police recommends if that prompt is erroneous. That is to say, this individual is adamant that there is a criminal background and how to go about obtaining additional information. But now assume, if you will, that I have put in a name, date of birth, and identifying information that reflects there, in fact, is a criminal record for this individual. I've blackened that out in these screens because I've used actual names. The individual whose record I'm going to show you now is part of my very extended family. And I am very grateful to him that he gave me permission to share his criminal record so that you could see what that looks like, because he knows how important expungements are in terms of returning and acclimating fully into society. So when you get an iChat that has information, a criminal record for an individual, there are 3 segments: the arrest segment, the charge segment, and the judicial segment. The arrest segment tells when the person was arrested and the department and agency that the arrest occurred, what they were arrested for. The charge segment reflects what the prosecutor determined to charge. And then the judicial segment is the dispositional segment. And that is important not only because it identifies what the convictions were, but the court in which those convictions occurred. And if you have individuals with multiple convictions and multiple courts, what you must do is file an application in each one of those courts. There is no central repository for expungement, so you have to go back to the court of record. So you'll see there was one arrest for assault excluding sexual violence. The prosecutor charged child abuse, domestic violence, resisting and obstructing, and another felony. And ultimately, the disposition that my beloved extended family member had included a charge of domestic violence and the felony assaulting a police officer. And unfortunately for my loved one, this was not the end of the story. Here is yet another entry. And this one is, again, a charge, an arrest date out of the Hampton Township Police, charge out of the Bay City Prosecuting Attorney's Office, and then the disposition out of the Bay City Circuit Court. If we believe that there is erroneous information, either a lack of information or wrong information attaching convictions, say that Bay County matter did not, in fact, my family member was not involved in that, then the iChat identifies what one would have to do to correct a record. And there are two scenarios presented. One is that the wrong person was convicted. These records do not belong to my client. The other is, this is my client, but the records are incomplete or inaccurate. And you'll see that the state police has very specific instructions which they provide in order to make those corrections. And that's important to know. And I know Rebecca Zaris and I encountered, again, on our traveling expungement clinic, situations where it isn't an easy fix. And you have to be able to advise the client that there are additional steps, and then you walk them through what those steps may be. One reason that records may be inaccurate is that law enforcement didn't remove after someone was either acquitted or not charged for offenses, and finding out how to go about remedying that can sometimes require a little bit of legwork. But I offer that slide to you so that you can see what options are available, and you will, of course, let your client know accordingly. And so, as you know from Rebecca's presentation, there are many different iterations of the clean slate legislation. What do I do if I have multiple felonies? There's a form for that, as well as one bad night conduct or same transaction conduct. The mix of felonies and misdemeanors only, human trafficking victim, and now OUIL. And your head may be spinning. I know mine was when I came to figure out just the complexity of what seems to be a pretty straightforward, simple way of helping people get rid of a criminal record. And you may say, oh my gosh, I don't even know where to go to find those forms. And what I want to suggest to you, if you have not yet done an expungement or utilized anything, that you utilize Michigan Legal Help. Michigan Legal Help has SCAO approved forms that may be used not only by self-represented litigants, but also by attorneys who are helping individuals with their legal problems. So Michigan Legal Help is the place to go. And on their cover page, if you scroll down, you'll see that you can go to a place, crime, traffic, and ID, and that is where you find expungement information. Once you click on that, you will be asking, you will be asked a series of questions that you're going to be asking your client. And it's very intuitive. It's like TurboTax. If you've done your taxes, if you haven't, you better get on it because Monday's the deadline. But assuming you've done your taxes, you know what I'm talking about, right? It asks you questions, you fill in blanks, and then it progressively leads you to an outcome. And Michigan Legal Help knows how to decipher based upon the information that the responses that you put in, it can decipher what forms to utilize. A couple of things, again, going back to my my loved one, and I do love him, and I want him to integrate into the community, but he's got some pretty significant convictions that are relatively new, and time will tell whether he will be able to shed any of those. But you need to, again, when you're filling out the applications, as I said previously, every court where there is a conviction is where you have to take that expungement application. And there are a number of things that you need to do in addition to filing that application. You need actually 5 copies of it, and the signature of the client must be notarized. If you don't have a notary or access to a notary, banks will notarize. I know there are services that will charge a fee for notarization, but that's important. You need 5 copies of a certified conviction per application, letters of community support, and you're going to need to secure a notice of hearing in each of the communities where you have convictions. You also are going to need fingerprints from your client, and those prints have to be attached to each conviction. So when you file the application, there are requirements that you serve. Not you file the original in the court. You serve the Attorney General's office, the local prosecutor, and the Michigan State Police. Michigan State Police also requires a fee of $50. That's when they're going to do the comprehensive background check. They are the ones who get the fingerprints as well when you get your client printed. And so you're going to serve everyone, and including notifying them of the date of the hearing. And then you're going to prepare the client. As I said in my preliminary remarks, just because someone is eligible on paper does not mean that they necessarily will be given or granted an expungement. And this is where your comments to your client are vital. You know, Sunday best, be on time. If you're remote, you're in a room where there is no noise and where you can give your direct attention to the judge. You should also prepare your client to testify. And candidly, it is not enough to just say, expect you're going to have some questions asked of you. I would, as an advocate, go through the client's record and prepare their testimony with them, telling them, you know, be honest, of course, always. You speak in complete sentences, and be ready to convince that judge that you are deserving of an expungement. And, you know, it always touched my heart. I would ask the question just because I was more curious than anything else. Why is it you need the expungement? And I've heard reasons from as simple as I want to be able to volunteer in my child's school, to I can't get a job, to you name it. And those are the things that you will want to tease out with your client, again, so that they tell their story very persuasively. Your client and you, if you're accompanying him or her, will need to show up at court for that hearing and bring with you the proposed order and copies granting the expungement. As a trial court judge, I didn't have those readily available. We could sometimes provide those things, and I know that well, we did every time if someone was lacking, and I think that Judge Jokic would do the same. But I also know that there are judges who say, no, you didn't bring me the paperwork. Until you do, the expungement's not granted. So that's why bringing those to court with your client is vital. Okay, here's my brag. Here is my brag. These were a number of students, professors, judges. You can see Chief Justice McCormick and Detroit Mercy's former Dean, Phyllis Crocker. But these are some of the people who assisted us with our expungement clinic, which lasted 2 weeks, and we hit 6 different jurisdictions. And, the smiles we have for the camera, this came right at our kickoff before we got in our vehicles and headed north. Those smiles are nothing like the smiles that we had when we knew that we had a client who was eligible, and then we later learned that their conviction had been set aside. And I know that you will beam as well once you achieve that on behalf of your client, and your client will be grateful. So those are my slides, and I know I've spoken quite a bit. I don't know whether there are any questions or whether my co-presenters, Kamau or Ann, would like to offer any supplementary commentary, but I would, I'm going to stop my lips and let someone else take it away.
I have a couple of things. First is in regard to one of the slides about setting a notice of hearing. A lot of courts won't do that before you file your application, which is okay. You should definitely contact the clerk and see if they will. But if they don't, you can file it without a hearing date, and then they will. If you're on the case as like fully appeared, then you should get notification, although I've had some trouble with that too. Otherwise, you can work with the judge directly once they receive the application and the response from the Michigan State Police and the Attorney General's office to get your hearing set. I think
the critical,
but
I'm sorry.
No,
The critical point is you need to give enough time for the state police to run the background check. So you don't want to have a hearing set any sooner than like 6 to 8 weeks out to give them sufficient lead time. Otherwise, you all are going to be getting an adjournment and coming back another time.
Yeah, and it's dependent on the court. Oakland County, I think, is mostly caught up now, depending on the judge, and 6 to 8 weeks would probably be fine. But Wayne County, it could be 3 months. I think they're working on it, but you just never know. So that's just a tip in case you feel like you're at a crossroads, you're really not, and you can just work with the clerks on that. And then the other thing, we did have a question kind of lost in the middle of the chat, which is whether there are any tips you can give regarding the letters of support, specific information to include, or like a number of them that you suggest.
Yes, I think your letters of support will come from members of your client's community who have either seen changes or have seen hardships and can speak to how a set aside will advance the needs of, will advance this person in society. Church members are always great, employers, loved ones. I don't know that there's any set number, but you want to, I think it does make a meaningful impression when you feel that person's tribe has shown up with them. And I want to say, I see Summer on the screen. Summer and Rebecca both were part of the Traveling Expungement Clinic, and Summer, I didn't see your name until just now. I apologize for leaving you out.
And I will say, to the judge's point, you also want to tailor some of these support letters to the type of offense person is trying to expunge. So with this new DUI law, for example, you may want evidence of sobriety or AA attendance. So that's something to think of as well when you're filing these types of applications.
Can I speak a little bit more about that question? Because I was the one that sent it out. And do we have time, Paulina?
Yep.
Okay, great. So I do a lot of driver's license restoration work in my practice. And so, you know, the hearing board has given letters, and back, you know, before they changed how those forms looked, there was actual guidance about what those letters should include. So I'm assuming that, especially when it comes to alcohol related convictions, that those would be similarly situated and those would be easy to tailor. And, you know, I go through those letters with my clients extensively to make sure that they make sense and that they are representative of knowing my client to the best of their ability to know them, right? So I'm assuming it would be the same type of thing. I would just want to make sure that I give guidance to my clients when I'm asking them to provide me letters of support. I wouldn't want them going in blank, because then you never know what you get. And it takes even longer to get those things in an order to where you would want to file that with an application. So I was hoping that the courts would have done something similar to the hearing board, but I guess we can create our own. Okay, thanks, Judge. I appreciate you.
Yep, sorry.
No, that's okay. I just, you know, when you're giving guidance to your clients, this is going to be an intimidating situation for them to begin with. Coming back in front of a judge asking for, I mean, this is the ultimate gift of a clean record. You want them to be put in the best light forward. So
Yeah, you know, so even talking about, I want to go to school, but I can't qualify for student loans because I have a felony on my record, and how this will help my family. Those kinds of things I think are certainly very meaningful. But then when you have the tribe as well of people who are able to speak to the character of the person, because you're asking your judge, take a chance on this person, right?
Right.
And so that's why that also, I think, is very appropriate and encouraged.
And this will be my final question on this. In your review of these documents that are coming before you, would you say 3 to 5 letters is sufficient?
I think so.
Okay. Thank you.
Mhm.
I'll just say one other quick thing on that before I turn it over to Kamau, is that in my limited, although interesting experience so far with these, the question, like, legally is really about like reformation of character and whether or not this person will be a hindrance to society. So all those positive things about what they do in terms of volunteering or being involved in a church or maintaining gainful employment and stuff like that goes a long way, as well as just like not, you know, having any other stuff on the record. So okay, so last thing is that we'll hear from Kamau Sandiford on how you can get plugged in with some of Safe and Just Michigan's expungement fairs and other volunteer opportunities.
Yeah, so thank you, Paulina. So Paulina, I sent you an email with a list of our upcoming expungement events, which you can circulate amongst the group. We have some pretty big events coming up. On the 30th, we have Oakland County Expungement Fair, which is going to be at the WLAM Sports Complex in Pontiac. On May 4th, we also have Genesee County Expungement Fair. I don't know if you guys remember last year, they had a pretty big one. I think it was roughly 900 people showed up for that particular fair. So that's going to be on May 4th. We're also in the process of working on a Wayne County, a big expungement fair in Wayne County. We haven't finalized the date yet, but once we do, we'll let everyone know. I also sent you, Paulina, our volunteer attorney form. So what we have is a form that we send out to attorneys. They can fill it out and they can indicate which region of the state they would like to participate. So, you know, for example, Wayne County would be Region 4. So if you check Region 4, every time we have an event in that particular region, we'll notify you of that event, and then you can volunteer for that event, because we're always looking for legal support the day of the fair. So obviously, any support you guys can bring will be much appreciated. In addition to that, a number of these fairs are doing pre-screening. So if you've ever been involved with these types of expungement fairs, you know that there's always a long line. You know, might be 200-300 people in line. And so the idea behind pre-screening is to run the iChats ahead of time. We have the person screened by attorneys, and then the eligible people are notified that they are eligible and they are invited to the fair. And then we let the people who aren't eligible, we let them know ahead of time as well, so that they don't waste time coming down to the fair. So I say all this to say there are a number of ways that attorneys can support, obviously providing assistance the day of the fair, but you can also provide remote support via pre-screening. So if you indicate in the form that you want to provide remote support, then what will happen is the next fair that we have pre-screening, I will let you know, hey, there's a fair coming up. Would you like to provide remote support? And then normally what happens is we will send you a batch of iChats, so like maybe 20 iChats in a folder. And then we'll ask you to review those iChats to see who's eligible, who's not. And again, that's another way to help out with respect to these expungement fairs coming up. This is kind of off topic, but it's something that I believe Tanya brought up with respect to the driver's license restoration issue. One of the things that we've seen, especially with the new DUI law going into effect, is people think that by expunging their DUI offense, it will lead to the restoration of their driving privileges. So just be mindful that it's two separate actions essentially, and that's something we've had to kind of tell people when they come seeking to get a particular DUI expunged. They would still have to petition the Secretary of State to get their license restored. So, yeah. And then I'm going to include the volunteer attorney link in the chat as well. So again, feel free to sign up if you guys are interested in any of the upcoming expungement fairs. Thank you.
Okay, thanks very much. Are there any final questions for any of the speakers? Yeah, Fatima, if you want, you can just talk.
Yeah, sorry, I just clicked the link and it says page not found.
We're coming up on a full moon.
That was my only comment.
If we can't get it repaired right away, I'm gonna follow up with an extensive email of all the stuff, all of the links, everything that Judge Rick put in her slides, as well as some stuff that I use. One thing that I find very helpful is on the Attorney General's website, there's a checklist. So if you've never done it before, it's like you really can't screw it up if you just follow everything in order. And I have one with personal notes on it that I'll use because it just clarifies certain things. So yeah, and I'd offer myself for anybody to reach out if you're doing a first time application and have questions. And I think that's probably everything. Thanks again to the
I
speaker.
just sent the link again. It should work now.
Oh, okay.
Great. Yep, that works. Thank you.
Paulina, I see that Azal has asked whether you have to be licensed in order to volunteer. I think that's directed toward Kamal, but I will say we did, we had an attorney who oversaw law students in our clinic, and I would assume as long as there's an attorney, Kamal, that non-licensed law students and attorneys to be can still participate.
Yeah, most definitely. And in fact, I'm glad you brought up that point because we're always looking for more law students at these fairs. Um, Obviously, I have a connection with Cooley Law School, but so I've been able to get some Cooley students. But if you guys have relationships with any of the other law schools, feel free to share that information as well.
Sounds good.
Thank
Well,
you.
thanks again, everyone, for your time. Also included in the follow-up email, which I'm hopeful to get out tomorrow. I do have to receive the recording